and welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by LiveLaw. I'm your host, Ostika Das. I'm a lawyer practicing in Delhi, and I'm here to take you through and break down the most significant updates from the week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. But remember, for a more in-depth understanding, do visit LiveLaw's website at www.livelaw.in. So let's get started. In a first-of-its-kind development, sitting Allahabad High Court Judge Justice Yashwant Varma moved the Supreme Court this week against an in-house inquiry report that indicted him in the controversial cash-at-home row. This matter arose from a fire at his then official residence in Delhi in March, when a large sum of cash was discovered in an outhouse. Following public outrage, a 3-judge inquiry committee was constituted, which examined 55 witnesses and relied on photos and videos from the Delhi Fire Department before concluding that Justice Varma and his family controlled the premises and that he had failed to give a satisfactory explanation for the cash, dismissing his defense of a larger conspiracy as unconvincing. This report was sent to the highest constitutional authorities for action after Justice Varma refused to resign. In his petition filed on 17 July, Justice Varma has now named the Union of India and the Supreme Court as respondents. He alleges that the inquiry process was biased and predetermined and that adverse inferences were drawn against him without concrete proof, essentially reversing the burden of proof. He has also contested the recommendation made by the then Chief Justice Sanjeev Khanna to the President and Prime Minister seeking initiation of impeachment proceedings against him. This move comes just days ahead of the monsoon session of Parliament, where the impeachment motion is likely to be introduced. In a closely watched case this week, the Supreme Court heard 2 petitions over the film The Udaipur Files, which portrays the brutal 2022 killing of Kanhaiya Lal. One petition has been filed by an accused in the murder case, claiming that the movie threatens his right to a fair trial. The other is by the filmmakers, who are challenging a Delhi High Court order staying the film's release. The bench of Justices Suryakant and Joymallo Bagchi adjourned the hearing to next Monday, since the centre is currently reviewing the CBFC's certification of the film. The court stressed that the government, under the Cinematograph Act, has powers to re-examine and even revoke a film's certification. Senior advocates Kapil Sibal and Menaka Guruswamy, appearing for the objectors, argue that the film spreads hate, puts the judiciary in a bad light, and jeopardizes the rights of under-trial prisoners. Gaurav Bhatia, for the producers, insisted that the film merely criticizes extremism and that it has been lawfully cleared by the CBFC. The court, however, said releasing the movie before the government's review would render the objectors' petitions infructuous. Given that compensation is possible in cases of unjustified delay, the balance of convenience for now lies with the petitioners opposing the release. The Supreme Court is closely monitoring the case of Indian nurse Nimisha Priya, who faces the death penalty in Yemen for the 2017 death of her business partner Talal Abdo Mahdi. Convicted of murder and sentenced to death in 2018, her appeals were rejected and her execution was initially scheduled for 16 July. This week, the court heard a plea by a private group, the Save Nimisha Priya International Action Council, seeking permission for its representatives to travel to Yemen and negotiate blood money under Sharia law. The group proposes to offer 1 million as compensation to secure a pardon for the victim's family. In response to this plea, Attorney General R. Venkataramani, appearing for the Union government, told the court that India has already gone as far as it can, pointing out that Yemen is not a country with which India has normal diplomatic engagement. Blood money, he said, is a private legal arrangement, and India has tried to intervene quietly without complicating the situation by making things public. He said, and I quote, "There is a point till which the government of India can go. We have reached that." However, later in the week, the court was informed that thanks to private diplomatic efforts, including intervention by Islamic scholar Kanthapuram A.B. Abubakar Musliar, her execution has been temporarily stayed. The organization has also sought permission to send 2-3 members along with a representative of the cleric to Yemen to initiate talks under Sharia law. The Attorney General remained non-committal, saying that while the government is making private efforts, no formal commitment can be made at this stage. He also cautioned against steps that might be counterproductive, but said that the postponement of the execution was a positive sign. While refraining from passing any directions to the centre, the bench of Justices Vikram Nath and Sandeep Mehta has now permitted the petitioner to formally approach the central government for permission to travel. This matter has been posted for hearing on August 14th. This week, the Supreme Court reprimanded the SIT formed by the Haryana police to investigate Ashoka University professor Ali Khan Mahmudabad over his social media posts about Operation Sindoor. FIRs had been registered against him under provisions of the new Bharatiya Nyaya Sanhita, alleging threats to national integrity and communal harmony. Senior advocate Kapil Sibal informed the court that Mahmudabad was being summoned repeatedly and that his devices were seized and his 10-year travel history questioned, far exceeding the court's earlier directions. He argued that Professor Ali Khan Mahmudabad was being subjected to what he described as a roving inquiry. While ASG SV Raju attempted to defend the proof by saying that it was too early to draw such inferences, a bench led by Justice Suryakant was unequivocal. It reminded the state that the May 28th order had directed the state to focus narrowly on whether two specific posts attracted criminal liability. Further, the court recorded that since Mahmudabad had cooperated and submitted his devices, no further summons should be issued to him. Not only this, but the SIT has also been asked to complete its investigation within 4 weeks, as opposed to the 2 months extension sought by the state of Haryana. Importantly, the court also noted that Mahmudabad's interim bail only restrains him from discussing the sub judice matter, but does not restrict his freedom of expression otherwise. In a setback for RJD leader and former Bihar Chief Minister Lalu Prasad Yadav, the Supreme Court has refused to stay the trial in the CBI's Land First Jobs scam case. Yadav had approached the court challenging a Delhi High Court order that declined to halt proceedings against him. But the bench of Justices M.M. Sundaresh and N. Koteshwar Singh dismissed his appeal, holding that it was merely against an interim order and did not merit interference at this stage. Senior advocate Kapil Sibal, appearing for Yadav, argued that the CBI began its investigation without the mandatory prior sanction under Section 17A of the Prevention of Corruption Act, which protects officials from prosecution for actions taken during official duties. However, the CBI responded that the alleged offences occurred before Section 17A was introduced in 2018 and hence the provision would not apply. While refusing to stay the trial, the court did grant one relief. Yadav has been exempted from personal appearance in court. The bench also urged the Delhi High Court to expedite the hearing of Yadav's challenge to the trial court's cognizance. This week, the Supreme Court has ruled that secretly recorded phone calls between spouses can be admissible as evidence in divorce or matrimonial proceedings. This case involved a husband who submitted a series of his wife's phone calls to prove allegations of cruelty. The family court accepted its evidence, but the Punjab and Haryana High Court later rejected it, citing a breach of privacy. However, a bench of Justices B.V. Nagaratna and Satish Chandra Sharma has now reversed the High Court's ruling, clarifying that Section 122 of the Indian Evidence Act, which is now Section 132 of the Bharatiya Saksha Adhiniyam, does provide for confidentiality in spousal communication, but this does not apply when the husband and wife are parties to a case against each other. The judges clarified that this section does not deal with the broader right to privacy under Article 21 of the Constitution. Instead, the law balances the right to a fair trial with the need to prove one's case, and in this context, secretly recorded conversations can be relevant. Rejecting the argument that allowing such evidence would promote snooping, the court categorically stated that in cases where a marriage is already strained enough to warrant recording, domestic harmony is already in question. With this, the Supreme Court allowed the husband's appeal, setting aside the judgment of the High Court. This week, the Delhi High Court quashed charge sheets filed against 70 Indian nationals who had been accused of sheltering attendees of the Tablighi Jamaat congregation during the COVID-19 lockdown in 2020. The FIRs, 16 in total, had alleged violations under Section 144 of the CRPC and offences under Section 188 IPC, the Disaster Management Act and the Epidemic Diseases Act. But Justice Neena Bansal Krishna found no evidence that any of the accused were aware of the prohibitory order or had taken part in any act that amounted to spreading the virus. The court observed that the prosecution's claims were based on vague assertions. There was no proof that the accused had knowledge of the prohibitory notification under Section 144 CRPC, nor was there any material to indicate that they had gathered after the notification was issued. In fact, they had already been at the Markaz when the lockdown was imposed and were unable to leave once movement restrictions were enforced. Justice Krishna stressed that remaining at the Markaz during the lockdown did not amount to any offence, particularly when there was no evidence of any unlawful assembly or demonstration. She also pointed out that none of the charge sheets claimed that the accused had tested positive for COVID-19 or had violated quarantine norms. Applying the principles laid down in the landmark Bhajanlal case, the court then ruled that continuing the prosecution would amount to an abuse of the process of law and quashed all the charges. Reigniting the debate around free speech and national security, the Bombay High Court this week upheld the constitutionality of the Unlawful Activities Prevention Act and Section 124A of the Indian Penal Code, which criminalizes sedition. A division bench of Justices Ajay Gadkari and Dr. Neela Gokhale held that the UAPA in its present form is constitutionally valid, dismissing the challenge raised by multiple petitioners, including Anil Babura Bele, who had been served a notice by the NIA in July 2020. The petitioners, represented by Advocate Prakash Ambedkar, argued that the UAPA grants sweeping arbitrary powers to the executive, allowing it to designate individuals and organizations as unlawful without clearly defined criteria. They contended that this infringes upon fundamental rights and undermines due process. The sedition law, Section 124A IPC, was also challenged as being outdated and misused to suppress dissent. The court, however, did not find merit in these arguments and dismissed the petitions. It's important to note that the operation of Section 124A IPC is already in abeyance pursuant to directions of the Supreme Court in S.G. Vombatkere versus Union of India, allowing the centre to reconsider the provision. Also, the new Bharatiya Nyaya Sanhita 2023, while omitting the word sedition, introduces Section 152, which criminalizes acts endangering the sovereignty, unity and integrity of India, with punishments up to life imprisonment. In a scathing indictment of official apathy, the Madhya Pradesh High Court this week fined the state 5 lakh rupees for failing to promptly register an FIR in a sexual harassment case against the former Vice Chancellor of a national-level yoga and physical education institute. The case dates back to 2019, when a woman yoga instructor accused the VC of repeated inappropriate physical contact and demands for sexual favors. Despite multiple complaints, authorities failed to take timely action, and an FIR was registered only after the Supreme Court intervened. The Internal Complaints Committee eventually found the VC guilty, concluding that his behavior was demeaning and unworthy of somebody holding a high public office. Yet, the delay in action persisted, and an FIR was registered under the sections 354A, 509 and 120B IPC only after a special leave petition was moved before the Supreme Court. Justice Milind Ramesh Phatke, while delivering the verdict, held that the state accountable for police inaction and ordered 5 lakh rupees to be recovered from the erring officials personally. Additionally, the court directed the former VC to pay 35 lakh rupees to the complainant for loss of income, reputation and the trauma suffered. The institute itself was fined 1 lakh rupees for failing to protect the complainant and delaying justice. Congress leader Rahul Gandhi was granted bail this week by a Lucknow court in a criminal defamation case related to his remarks about the Indian Army during the Bharat Jodo Yatra. Gandhi personally appeared before the MP-MLA Special Magistrate Court after skipping 5 previous hearings. The complaint, filed by former BRO Director Uday Shankar Srivastav, relates to Gandhi's December 16, 2022 statement alleging that Indian soldiers were being thrashed by Chinese forces during the Arunachal Pradesh border clash on December 9. The complainant claimed that such statements defamed the Indian Army and lowered its morale. After the Allahabad High Court refused to quash the case in May, holding that freedom of speech under Article 19(1)(a) does not extend to defamatory statements, Gandhi had no option but to appear and seek bail. The Court of Additional Chief Judicial Magistrate Lalu Prasad granted him bail and listed the matter for further hearing. This case adds to Gandhi's mounting legal battles, besides reigniting the debate over the boundaries of free speech when it comes to comments about the armed forces and other national institutions. And that's a wrap for this week's Legal News Roundup. I'm your host, Ostika Das, and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged, and stay tuned to LiveLaw. Thank you for watching.